not on was because originally the appellants were going to appear as litigants in person. And if it's litigants in person, we don't live stream it except in exceptional circumstances. But now that they've got the great benefit of having your pro bono advice and representation, we'll live stream in the normal way unless anyone has any objections.
I'm grateful.
No, thank you very much. Thank you. Now, so presumably you want us to go to tab 1.
Yes, and I was going to begin actually with section 79 because it's central to the way the
Certainly.
statute works, and that is at page 13. So subsection 1 of section 79 provides that an RTM company wishing to make a claim under this legislation must do so by giving notice of the claim. And that document is defined as the claim notice, an expression that is then used in other provisions of the Act. Subsection 6 then says this at page 1.3. The claim notice must be given to each person who on the relevant date is a landlord under a lease of the whole or any part of the premises, party to such a lease otherwise than as landlord or tenant, or a manager appointed under Part 2 of the Landlord and Tenant Act 1987. So that identifies 3 categories of person who must be given the claim notice in 79.6. Now, what happens is once the claim notice is given to those persons, they are then entitled under section 84 to serve a counter notice if they wish to dispute the claim. And then the RTM company is entitled, if it wishes to pursue it, to apply to the first-year tribunal for a determination that it was entitled to acquire the right to manage. Now, section 88, with which this appeal is concerned, is on page 26. And it says this. RTM company is liable for reasonable costs incurred by a person who is landlord under a lease of the whole or any part of any premises, party to such a lease otherwise than as landlord or tenant, or a manager appointed under Part 2 of the 1987 Act to act in relation to the premises or any premises containing or contained in the premises in consequence of a claim notice given by the company in relation to the premises. And then skipping subsection 2 and going to 3, it says, RTM company is liable for any costs which such a person incurs as party to any proceedings under this chapter before the appropriate tribunal. Only the tribunal dismisses an application by the company for a determination that it is entitled to acquire the right to manage the premises. Any question arising in relation to the amount of any costs payable by an RTM company shall, in default of agreement, be determined by the appropriate tribunal. So that's the key provision. And my ladies, my lord, we make 5 points about the meaning and nature of this provision. First, subsection 1 creates a statutory liability which does not depend upon the making of any order by a court or tribunal. And in that respect, there is an important distinction between section 88 and the costs regime in the High Court. Where the High Court makes a costs order, say at the end of a trial or at the end of the hearing of an interlocutory application, it does so in exercise of the powers conferred upon it by section 51 of the Senior Courts Act 1981. And section 51 gives the High Court a general discretion in respect of any costs of or incidental to proceedings in that court. But where the High Court makes a costs order under that provision, the liability of the paying party arises under that order. It does not arise under the statutory provision itself. Put another way, without the costs order, there would be no liability to pay any costs, even in an amount to be quantified. By contrast, under section 88(1) of the 2002 Act, liability arises under and by virtue of the statutory provision itself without the need for an order. So that's my first point, that 88(1) creates a liability that is exclusively statutory. Second, and following from that first point, the only function of the tribunal under section 88 is to determine the amount of the statutory liability if it is not agreed. one sees that if we look again, please, at subsection 4 at the bottom of page 26, one sees that what it says is that any question arising in relation to the amount, and I'd emphasize the word amount of any costs payable by an RTM company shall, in default of agreement, be determined by the appropriate tribunal. So if I can put it like this, what subsection 4 confers on the tribunal is not a jurisdiction to make costs orders generally, but a jurisdiction to quantify a statutory liability. I'm not sure if that's controversial, but I should perhaps show the court one authority to make that good. And that is the post box case in the Upper Tribunal, which is Authorities Bundle Volume 2, tab 27, page 394. Tab 27, page 394. And if I can invite the court, please, to go to paragraph 23, which is at page 400. It's at the bottom of page 400. What the Upper Tribunal said was this, at paragraph 23, I accept that the liability to pay costs is entirely statutory. Moreover, it is not dependent on any costs order being made by the tribunal. Liability arises in accordance with the terms of section 88, and the only function of the tribunal is to determine the amount of costs payable in default of the parties' agreement. We respectfully agree with that, and that reflects the first 2 points I have just endeavored to make about section 88. Now, my third point is this.
This is what Upper Tribunal.
Upper Tribunal, my lord.
Yes. Thank you.
My third point is this. The statutory liability under section 88, subsection 1, arises only if costs are incurred by certain specified persons. That is to say, someone who falls within one of the 3 categories of person identified in subsection 1. There is no liability under section 88 to any other person, nor does any such other person have an entitlement to costs, even if they are party to proceedings in the first-year tribunal. So it turns, if I can put it like this, on who you are, not whether you are a party. And the Upper Tribunal in this case accepted that proposition, my third point, and that finding is not challenged by Assethold in the respondent's notice. Just for the court's note, I wasn't going to turn it up, that is at paragraphs 21 to 22 of the Upper Tribunal's judgment. That's co-bundle tab 7, pages 89 to 90.
So, for example, a tenant who was not content with the process would never be able to claim.
Indeed, my lord. That's actually a point I was going to come on to make, which is the tenant can't get costs even if they win, and even if the opposition to their claim is wholly unmeritorious, because Section 88 is a one-way cost provision.
Yes, that's something that is neither the RTM company nor anyone else, such as another tenant who's not interested in
Indeed.
proceeding with the
Indeed.
RTM process.
Indeed.
But it also means if you serve your claim notice on somebody and they say this property has nothing to do with me, then they don't get any costs.
They don't.
Even if they're joined as parties wrongly to the proceedings.
That's right, my lord.
And even if they turn up and say, I shouldn't have been joined to these proceedings, I'm not a landlord, I've got nothing to do with this property.
That's right. And I can see why, certainly to litigators in the courts, it seems slightly odd that you litigate, you win, but you can't get your costs. I mean, that's the opposite of what would happen in the High Court. But I'm going to come on to submit that that's a consequence of 2 things. One, the fact that Parliament has not conferred on the first-year tribunal a general cost jurisdiction as one has under Section 51. And the second is that the statutory cost liability is expressed to be applicable only if you're not only a party, but also have a certain status. And you either do or don't. If you don't have the status, you fall outside the statute. So that's what causes what I would absolutely accept is on its face a seeming anomaly, which is you're put to the expense of failed proceedings and you can't recover your costs. But that's a consequence of the two factors I've mentioned.
So you may be coming on to this, but there's also two categories of costs, aren't there? There's the costs of investigating
Yes.
the claim and the costs of proceedings.
Yes.
If you're the right person, as it were, Section 88 can cover both.
That's absolutely right, my lady. The only difference is there is an additional restriction on your ability to recover costs in the second category, that is to say the cost of proceedings, which is that the claim must have been dismissed by the tribunal. But subject to that, I respectfully agree. So that was my third point. My fourth point is that the persons specified in Section 88(1) include a landlord, so that's subsection 1A, but they do not include, and this perhaps picks up on the point my Lord Justice Nugee just put to me, they do not include someone who's asserted to be, but is not in fact a landlord, even if they become a party to proceedings in the FTT. Now, what is of some interest is that the language of subsection 1, so the three categories of person, one gets exactly the same language in other provisions in this chapter. For instance, section 83(2) and section 79(6). So the draftsperson must have intended that these words mean the same thing in each of these provisions. Certainly in the other provisions, there'd be no reason at all to construe the word landlord as referring to anything other than somebody who actually is a landlord. And we say likewise under section 88. So that's my fourth point. And that fourth point is reinforced, we submit, by subsection 3 of section 88, which is the provision that says that an RTM company is liable for costs which a person incurs as party only if the tribunal dismisses that application. But what is important in subsection 3 is the use of the words such a person in the first line. RTM company is liable for any costs which such a person incurs as a party. Now, the words such a person refer back to the person specified in subsection 1. So what subsection 3 is saying is that costs incurred by such a person as a party are recoverable only if the application is dismissed. But that demonstrates, in my respectful submission, that it's not enough for cost purposes simply to be a party to FTT proceedings and to win. You must, in addition to being a party and winning, be such a person, quote unquote, that is to say one of the persons specified in subsection 1. And the proposition one can extract from that analysis is that being a successful respondent in the FTT is a necessary condition for recovering the costs of the proceedings, but it is not a sufficient condition. Those are the 5 points I wanted to make about the meaning and nature of Section 88 at this stage, but I make them up at the outset because they are, in my respectful submission, actually an answer to a point on which both the Upper Tribunal and the respondent in its submissions place much emphasis. They say there would be an obvious injustice if this appeal succeeds, because it means that a landlord which is put to the expense of failed proceedings cannot recover its costs. Now, I agree that that would be the consequence of the submissions I'm making, but I mean, this goes back to a point I made briefly earlier. But the suggestion that that is an injustice must, on analysis, depend upon the premise that Parliament's intention was to enable all successful parties to FTT proceedings to recover their costs. It's only if you adopt that premise could it be said that it is an injustice if there is a particular situation in which the successful party cannot recover its costs. But that premise, we would respectfully submit, is a false premise, both because the FTT does not have any general cost jurisdiction like Section 51, and also because, as I have endeavored to demonstrate, success in the FTT is only a necessary and not a sufficient condition for triggering the statutory liability under subsection 1. You must, in addition, have the status that subsection 1 refers to. And there is, my ladies, my lord, actually one further indication that this obvious injustice point is founded upon a false premise, which is that The RTM company can't recover its costs, even if it is successful, as I pointed out earlier, because there's just no power under Section 88 to award any costs to the RTM company. And what that means is that Section 88 is an instance of what is a relatively unusual phenomenon in English civil litigation, namely one-way cost shifting. But the fact that that's what Section 88 does tells us something about Parliament's purpose, which is that it wasn't to enable successful parties to recover their costs merely by virtue of the fact that they are successful. That's not what Section 88 is about. What it is about, and it has this in common with other provisions in this chapter, is that Parliament chose to confer various rights and obligations in a carefully drawn legislation in different circumstances on persons who have a certain status, such as landlord or tenant. You either do or you don't. Now, that's all I wanted to say at this stage about the proper construction of the 2002 Act, to which I will return in the course of my submissions. But I was going, if I may, now to turn to issue 1.
Yes, just before you do that, you say it's an example of one-way cost shifting, but I think what you're really saying is that's an inadequate description of what it is. It's not if you're on the landlord side you get your costs, and if you're on the tenants you don't. It's if you're on the landlord side and you fit within particular categories. So it's limited one-way cost shifting.
It's limited.
In favour of, you would say, these particular people.
Yes, my lord, I respectfully agree with that, yes. I think the point I was trying to make was, I agree with that. The point I was trying to make was, if Parliament's purpose had been that every successful party should recover,
yes,
then
no,
you would...
I understand that.
Yes,
but
yes.
I thought it was slightly dangerous for your argument to say it's one-way cost shifting, because the simple answer is, well, they're on the right side.
Well,
of
quite. Your lordship's quite right, yes. It's one-way cost shifting if you are within one of those categories. So it's, as your lordship put it, it's limited one-way cost shifting. Can I turn next to issue 1? And that is whether the estoppel identified by the Upper Tribunal is inconsistent with the principle, the existence of which is not, I think, in dispute, that the jurisdiction of a statutory court or a tribunal, the statutory jurisdiction of a court or tribunal cannot be enlarged by agreement or estoppel. Just as shorthand, I'm going to refer to that as the jurisdiction principle, and it's addressed in paras 24 to 47 of our skeleton argument. And as the court is aware, our case is that the Upper Tribunal's analysis is indeed inconsistent with the jurisdiction principle. And what I propose to do is to look first at 2 House of Lords authorities on the scope of that principle before addressing the Upper Tribunal's reasoning for rejecting our case on that point. Just to identify this at the outset, the proposition that I seek to derive from the 2 House of Lords cases is as follows. A statutory provision which contains a substantive as distinct from a procedural precondition to the exercise of a statutory jurisdiction is a jurisdictional provision which cannot be enlarged or restricted by agreement or estoppel. For example, a provision identifying the class of persons who may invoke the jurisdiction, or the types of claim which may be determined by the court or tribunal, is substantive, not procedural, and therefore jurisdictional. The first House of Lords authority is the Essex County Council case, which is Volume 1, Tab 19, page 238. May I summarize the facts quickly before I take the court to the relevant passage, just to put it in context? Now, the respondent in this case owned a freehold site, and that site was affected by road widening activities that the local authority was proposing to undertake. So in November 1959, the owner served a purchase notice on the local authority under Section 39 of the Town and Country Planning Act 1959, requiring the local authority to purchase the property which was affected by the proposed road widening activity. The local authority served a counter notice But Section 40 of the 1959 Act says that a counter notice must identify the grounds on which objection is made from a specified statutory list of 6 grounds. Now, one of those grounds in subsection E was that the claimant's interest in the land is not a qualifying interest. In the counter notice served by the local authority, it identified 2 grounds, C and D, but not E. So it did not identify the qualifying interest point as a ground of objection. Upon receiving the counter notice, the owners applied to the Lands Tribunal, as it then was, for a determination of whether they were entitled to require the local authority to buy their property, as they were entitled to do. What happened was, in the course of proceedings before the Lands Tribunal, it occurred to the local authority that there was actually a knockout point, which was that the owner's interest in the land was for reasons that don't matter, not a qualifying interest. And they invited the Lands Tribunal to decide that point as a preliminary issue. And it is important to emphasize the owners consented to that before the Lands Tribunal. So you've got a case where the owners actually consent to the Lands Tribunal deciding this point as a preliminary issue. In the Lands Tribunal, the owners won on the merits. Then the local authority appealed to the Court of Appeal. And at that stage, the owners for the first time took the point that the Lands Tribunal actually had no jurisdiction to determine this preliminary issue, and that their consent could not enlarge that jurisdiction because it was entirely statutory. And that's how the issue came before the Court of Appeal and then the House of Lords. The Court of Appeal rejected the argument, but the House of Lords accepted it. And they held that they can't be an estoppel. Can I invite the Court, please, to go first to the speech of Lord Reed at page 250. Picking it up in the final paragraph on page 250, Lord Reed said, but the appellants say that the respondents cannot be allowed to maintain this point now because they consented to the matter being dealt with by the tribunal. What in fact happened was that the appellants requested the tribunal to deal with this point as a preliminary point of law. This request was intimated to the respondents and they did not object. Then the respondents appeared before the tribunal and argued the point, but not being then alive to their rights, they did not protest. I need not consider whether this amounted to a consent widening the reference of the tribunal, because in my judgment it is a fundamental principle that no consent can confer on a court or tribunal with limited statutory jurisdiction any power to act beyond that jurisdiction, or can stop the consenting party from subsequently maintaining that such court or tribunal has acted without jurisdiction. If the High Court, having general jurisdiction, proceeds in an unauthorized manner by consent, they may well be an estoppel. And an arbitrator or other tribunal deriving its jurisdiction from the consent of parties may well have his jurisdiction extended by consent of parties. But there is no analogy between such cases and the present case. The tribunal in the present case had no power to state a case except with regard to some matter arising out of the exercise of its limited statutory jurisdiction, and this stated case does not deal with any such matter. I am therefore of opinion that the stated case was not properly before the Court of Appeal and is not properly before your lordships. Now, just pausing there, the distinction Lord Reed draws between High Court or arbitration proceedings on the one hand and statutory proceedings on the other is an important one, because the High Court has general jurisdiction. An arbitrator doesn't, but their consent derives from consent anyway. Their jurisdiction derives from consent anyway. So if what happened in this case had happened before an arbitrator or had happened before the High Court, it could have given rise to an estoppel. But the point Lord Reed is making is, if it happens before a court or tribunal whose jurisdiction is delimited by statute, then either it has jurisdiction under the statute or it doesn't, but consent is irrelevant. A similar point was then made by Lord Morris, just to show the other speeches in this case. That's at page 254. It's at the very bottom of the page. It begins with the words, the jurisdiction, and then we carry on over. The jurisdiction of the page 254. The jurisdiction of the Lands Tribunal is purely statutory and is limited by statute, and it was not open to the Lands Tribunal to deal with an objection which was never referred to it, nor could the Lands Tribunal, by the consent of the parties, assume a jurisdiction going beyond the provisions of the sections to which I have referred. And then at page, just at the end of that paragraph, actually, Lord Morris said the tribunal could not assume a jurisdiction with which it would only be endowed if certain steps had been taken and certain conditions satisfied, which I would respectfully submit is a clear encapsulation of the jurisdiction principle. Namely, are the statutory preconditions satisfied? If they are, you have jurisdiction. If they're not, you don't. And then finally, Lord Hodgson at page 258. About 12 lines into page 258 said, had the question been procedural only, no difficulty would have arisen, for the parties had consented to the course taken before the Lands Tribunal, but in my opinion, the jurisdiction of the tribunal is circumscribed by the terms of the Act, so that it has no power in this matter to do other than deal with the objections put forward within the statutory time limit of 2 months. The consent of the parties cannot confer jurisdiction where none exists, nor can any question of estoppel arise, for estoppel cannot enlarge the court jurisdiction of a court of limited jurisdiction. Now, the reference to what would have happened if the question had been procedural is of some assistance, because I accept, and I've always accepted, that if the relevant statutory precondition is procedural, then it can be the subject of waiver, agreement, or estoppel. And the most obvious example of that, it's a point made by Mr. Michael Barnes QC in his textbook, which I'll go to, is a time limit. There are statutory provisions which contain time limits, indeed even the Limitation Act, which can be the subject of an agreement, waiver, or estoppel. But if the relevant precondition to the exercise of a statutory jurisdiction is substantive rather than procedural, then it can't. And the rationale for that is presumably that when Parliament gives a court or a tribunal a limited statutory jurisdiction but makes it subject to substantive preconditions, the intention is that it is only appropriate to exercise that jurisdiction where those conditions are satisfied. So that's the Essex County Council case. The other House of Lords authority, which is in some respects an even more striking case, is Globe Elastic, which is Volume 2, tab 34, page 485. Again, I'll perhaps summarize the facts if I may. The case concerned the Redundancy Payments Act 1965. An individual, Mr. Vijashko, was employed for 22 years by a company called John Heathcote Limited. In 1970, he was told by this company that there was no further work for him, but that instead of leaving, he could join another company in which John Heathcote had a 50% interest, I think. And importantly, representations were made, both by the current and the prospective employer, that if you move across, you won't lose any of the benefits to which you're entitled under employment legislation. So the employee moved. 5 years later, the new company made him redundant. He brought a claim for a redundancy payment on the basis of continuous employment for over 20 years, so taking into account the time he had spent with the previous employer. Now, that claim fell to be determined by an industrial tribunal, which was exercising a statutory jurisdiction under Section 9 of the 1965 Act, which is quoted at page 496. So at just below letter F at page 496, Section 9.1, any question arising under this part of this Act as to the right of an employee to a redundancy payment or as to the amount of a redundancy payment shall, in accordance with regulations made under Part 3 of this Act, be referred to and determined by a tribunal. So that's the statutory provision. Now, the tribunal held that on the true construction of the 1965 Act, Mr. Vijashko's employment was not continuous. You couldn't take into account the time he had spent with the previous employer. but that the new employer was stopped from taking that point by reason of the representations they had made at the point the employee moved across. And on that ground, the Industrial Tribunal awarded a redundancy payment on the basis of 20 years, which was the maximum under the 1965 Act. The new employer, Globe Elastic, then applied to the Secretary of State for a rebate, which it was entitled to do under the Act, but only if the redundancy payment was made, quote unquote, under the Act. And that's set out in section 30, which is quoted at page 496, just above letter C. The liability of the minister to make a rebate is stated in section 30. Subject to the provisions of the section, the minister shall make a payment out of the fund to any employer who is liable under Part 1 of this Act. That's the key phrase, under Part 1 of this Act. So the issue before the House of Lords was whether the redundancy payment made by Globe Elastic, by reason only of an estoppel, nonetheless constituted a payment under the Act. In other words, whether the sum was due under the Act. And their lordships held that it was not. Can I invite the court to go to page 497, please, where the reasons for that are set out in the form of 3 propositions by Lord Wilberforce, just below letter F. Lord Wilberforce said if continuity means continuity with one employer, a tribunal applying section 1 of the Act could not properly have regard to continuity with 2 successive employers. The Act does not permit this. To take such latter continuity into account is to do something which the Act does not allow. It involves not merely an error within the jurisdiction entrusted to the tribunal, but acting outside the jurisdiction altogether. Point 2 probably doesn't matter. And then point 3 over the page. Even if anything in the nature of an estoppel arose that could not confer upon the tribunal a jurisdiction beyond that given by the Act, whatever force it might have as between employer and employee, it could not make the redundancy payment agreed upon, a payment which the employer was liable under Part 1 of this Act to pay, and so could not create a right of rebate. Now again, pausing there, my ladies, my lord, point 3 at letter B is we would submit actually making 2 different points. The second point, which is not relevant for our purposes, is that an estoppel between the employer and the employee could not bind the Secretary of State, a third party. And that's of course right, it doesn't matter for present purposes. But that's not the only point Lord Wilberforce is making. There's a prior point in the first 2 sentences of point 3, namely that an estoppel, even if it would otherwise arise as between employer and employee, so not the Secretary of State, just the employer and the employee, could not enlarge the statutory jurisdiction of the Industrial Tribunal to award a redundancy payment, nor could it convert something that is not in fact payable under the Act, but is nonetheless agreed to be paid, into a payment under the Act. So to put it another way, the 1965 Act contained various substantive conditions that had to be satisfied before a redundancy payment would fall under the Act. One of those substantive conditions was continuity of employment. The same employer must have employed you for 20 years or whatever period you're claiming for. Despite the fact that that condition was not satisfied, the tribunal awarded compensation on the ground that the employer was stopped from disputing that it was satisfied. And the House of Lords concluded that that was not merely erroneous, but amounted to an enlargement of the jurisdiction of the Industrial Tribunal. So the Globe Elastic case, in my respectful submission, demonstrates that a statutory provision containing a substantive condition, a substantive precondition, which has to be satisfied before a statutory jurisdiction may be exercised, cannot be enlarged by agreement or estoppel.
I mean, presumably on the facts of that case, the tribunal would have had, or may have had, jurisdiction to award a smaller sum.
Yes.
So you'd have to put it in terms of no jurisdiction to award that larger payment, or to that extent, no jurisdiction.
Yes, I respectfully agree, my lady. In fact, that's referred to in the judgment the industrial tribunal's award in respect of 5 years that the employer had spent with the second employer was properly made, and the rebate was also payable. So the debate was about the remaining 15 years, which the House of Lords found the industrial tribunal does not have jurisdiction to award. And in a way that demonstrates the submission I was just making, which is that if a substantive condition is not satisfied, then you can't make the order. And in some cases, it may be it's satisfied in respect of a part of the claim, and in others, it may be that it's not satisfied at all. But the point is that if it's not satisfied, then there's no jurisdiction to make the order. And just before I turn to the application of the law to our case, I should just very quickly show the court the way it's put by Mr. Barnes in his textbook on estoppel.
Just
yes,
before
of
you
course.
leave Globe Elastic, the dispute in Globe Elastic is between the Secretary of State and the new employer.
Yes.
Doesn't involve any formal challenge to a decision of the industrial tribunal.
No, it doesn't.
So the employee keeps his money, is that right?
The employee keeps his money. Yes, that's right. So what happens is the new employer doesn't get his rebate from the Secretary of State, but the
But
employer...
it would logically follow from what Lord Wilberforce says that the industrial tribunal had no business giving the employee 20 years.
Yes, it would follow.
Does that mean the employer could have gone back to a tribunal and said, it now appears that we paid when we shouldn't have done, and we can now appeal out of time? I mean,
Yes.
it leaves those things just unanswered.
It does, my lord, because as your lordship says, if in fact the industrial tribunal did not have jurisdiction, then presumably its decision was a nullity in respect of the remainder. So it may be that the employer could have brought an unjust enrichment claim, or perhaps gone back to the industrial tribunal to reopen it in some way. As I read the judgment, that didn't arise before the House of Lords, and it may be the employer didn't actually do that, one doesn't know. But the reason I was keen to emphasize that Lord Wilberforce's point 3 is actually making two separate points, is that one can't sideline this case on the basis that it's just concerned with whether the Secretary of State is bound by an estoppel, which of course the Secretary of State is not, because what this case is about is whether a payment made by reason of an estoppel constitutes a payment made under the Act. In other words, does it fall due under the Act? Because of course, and this is also a point made by Lord Wilberforce, if the employer actually agrees to pay more, that's a contract and you can enforce it in the ordinary civil courts. You just can't do it in the industrial tribunal. And that in fact, one of the arguments made by counsel on the other side was that it would be inconvenient if you have to go to two different fora to make the claim, and that's right. But that's again just a function of creating a statutory tribunal, but imposing on it substantive preconditions before an order can be made.
I mean, as you said, Lord Wilberforce's point 1 makes the point very strong, doesn't it?
Yes, indeed, my lady.
So it may be, and on the facts of that case, there was no jurisdiction of the industrial tribunal to confirm that award, but maybe the employee had some other recourse.
Indeed, and in fact, I'm sorry, yes, indeed. And in fact, that's a point that was made by counsel for the Secretary of State, Mr. Bingham QC and Mr. Scott QC. They refer to regulations under which the Secretary of State had the power, I think, either to consolidate claims or to allow the two claims to be tried together. So they were practical solutions. If you have an extra statutory agreement, you might be able to enforce it. But absent something of that sort, what this case demonstrates is that the industrial tribunal can't enforce that. I was going to go next very quickly to Mr. Barnes's textbook, which is in the same volume. It's tab 40, page 565. At paragraph 2.120 at page 567, the subtitle is Distinguishing between Jurisdictional and Procedural Requirements. And Mr. Barnes says, it's useful to revert to the distinction drawn by Lord Pearson. That's a reference to the Cammons Ballroom case, in which the relevant statutory requirement was found to be procedural rather than substantive. between jurisdictional and procedural requirements which have to be satisfied if a court or tribunal is to have jurisdiction. The obvious question which then arises is how exactly to distinguish between a substantive or jurisdictional requirement which cannot be the subject of an estoppel and a procedural requirement which can be the subject of an estoppel. It seems that restrictions concerning time limits or the format of applications to a court to exercise its powers are likely to be classified as procedural. By contrast, restrictions which concern the essence or content or the boundaries of what a court is to determine under a statutorily conferred power are likely to be jurisdictional in nature. To refer back to the Camels case, the jurisdiction of the county court is to determine whether to order the grant of a new tenancy to a tenant of premises used for business purposes. It seems extremely unlikely that where there was a contractual license as opposed to a tenancy of premises, the parties could, by the operation of an estoppel, confer jurisdiction on the court to order the grant of a new tenancy, since the essence of the jurisdiction depends on the current existence of a tenancy. Now, we would respectfully submit that that is a helpful summary of the distinction between jurisdictional and non-jurisdictional requirements, which is broadly the distinction between substance and procedure. Now, if one then applies those principles that we've just looked at to our case, the correct analysis we would submit is as follows. Section 88, subsection 4 of the 2002 Act, as I have already submitted, only gives the FTT a jurisdiction to quantify a statutory liability. That statutory liability arises only if certain substantive preconditions are satisfied. One of those substantive preconditions is that the person who incurred the costs must have a certain status as landlord or as a party to a lease, otherwise than as landlord. It is to be assumed for the purposes of my appeal, as opposed to the respondent's notice, that Assethold is not a landlord, and the FTT so found. On that assumption, it must follow, we respectfully submit, that any estoppel or agreement that Assethold is a landlord even though it's actually not a landlord would, one, enlarge the statutory jurisdiction of the FTT under subsection 4 by enabling it to quantify costs incurred by somebody who is not a landlord, and also impose on the RTM company a statutory liability that the statute itself does not impose. And we would respectfully submit that that is contrary to the jurisdiction principle, and therefore that the Upper Tribunal erred in law. So that's my positive case, as it were. But the Upper Tribunal's reasoning, which I need to address, it begins at paragraph 31 of its judgment, which is core bundle tab 7, page 91. Page 91, at paragraph 31, the Upper Tribunals referred at paragraph 31 to the jurisdiction principle. Another way of putting this, which the respondent sets out under point 6, but which I think properly belongs here, is that it is not possible to confer a jurisdiction on the court by estoppel. There is no jurisdiction to award costs under section 88 to a party who is not a landlord, and jurisdiction to do so cannot be created by estoppel. Then at paragraph 32 and paragraph 33, which I wasn't proposing to read out, the Upper Tribunal referred to the Benedictus case, which I'm going to deal with shortly. Then its conclusion at paragraph 34 at page 92 is as follows. In my judgment, if the respondent is estopped from denying the appellant's status as landlord, it is estopped from denying an essential fact necessary to establish the appellant's right to costs, it is not an enlargement of the jurisdiction of the FTT to award costs, which remains exactly as defined in the statute. Accordingly, there is no bar to the operation of the estoppel in this case, just as there was none in Benedictus nor in Plinton, where again the tenant was estopped from denying a necessary ingredient. So as we read that passage, the Upper Tribunal seems to have rejected our case on the jurisdiction principle on the ground that just as in Benedictus and Plinton, the estoppel in this case would not enlarge the statutory jurisdiction of the tribunal. And with great respect, we say that the Upper Tribunal misunderstood those authorities, which I'm going to turn to next. But it's actually necessary to start with an earlier case, Dutton, because that's the case on which Benedictus is in turn founded. Dutton is at volume 1, tab 18, page 228. Tab 18, page 228. Again, to summarize the facts, Mr. Dutton was employed in a poison gas factory, and in July 1916, he was affected by gas poisoning and was unable to work thereafter. Between 1916 and 1919, his employer made weekly payments of compensation to him, and some of those payments were described by both parties as payments made under the Workmen's Compensation Act 1906. So there was a form which said that, and it was signed by both parties. Then the payment stopped, and Mr. Dutton brought a claim in the county court to recover them. But the county court was sitting, the county court judge was sitting as an arbitrator under Section 1 of the Workmen's Compensation Act 1906, and was therefore exercising a statutory jurisdiction. The county court judge held that gas poisoning does not come within the 1906 Act because it's not one of the illnesses identified in the schedule. So it just doesn't apply to any illness that's attributable to gas poisoning, but that the employer was stopped from taking that point because of the representations made when the weekly payments had been made to Mr. Dutton. The Court of Appeal allowed the employer's appeal, and the judgment of Lord Justice Atkin, as he then was, has proved to be particularly influential in subsequent authority. It begins, picking it up at page 235. Now, about 5 lines into the passage, Lord Justice Atkin says, the right to compensation and the reference to the county court judge as arbitrator are entirely created by the statute. Employer and workman cannot by agreement give one another rights under the Act, which are not given by the Act, nor can they give to the county court judge jurisdiction to determine under the Act disputes which are not under the Act. Pausing there, we would suggest that the learned Lord Justice is there identifying 2 separate limitations on the ability to invoke an agreement or an estoppel. The first limitation is that an employer and workman cannot by agreement give one another rights under the Act, which are not given by the Act. And the critical words in that sentence are under the Act. Because of course you could do it by contract, and the contract would be enforceable in the civil courts, but you can't do it under the Act. And that is of course the same point that was made 50 years later by Lord Wilberforce in the Globe Elastic case, where he pointed out the redundancy payment, if there was an agreement, is not a payment made under the Redundancy Payments Act. So that's the first limitation. You can't, as it were, waive a substantive precondition and turn the payment into a payment made under the Act. Second, the employer and workman cannot by agreement or estoppel give the county court judge jurisdiction to determine under the Act disputes which are not under the Act. And that's what I have described as the jurisdiction principle. And they're of course very closely related. Now, Lord Justice Atkin then went on to make some further points in the remainder of page 235, in a passage that we would suggest requires close analysis. I don't know whether the court would like me to read that out, the remainder.
Read it to us.
Great, thank you. So just taking this in stages, starting with the third sentence in the next paragraph on page 235. So the sentence beginning with the words under these circumstances. Under these circumstances, in my opinion, it was not competent for the employer and workman by conduct or agreement to give jurisdiction to the county court judge to award compensation under the Act. Now that is a straightforward application of the jurisdiction principle, and it, we would suggest, supports our case on this appeal, because the reason why the jurisdiction principle was engaged in that case was that a substantive precondition to the making of an order by the county court judge was not satisfied, namely the existence of an illness to which the 1906 Act applies. Just as in this case, if we are right, a substantive condition for making an order under section 88(4) is not satisfied, namely that the respondent is a landlord. So that's the third sentence. But Lord Justice Atkin then distinguished between an agreement or estoppel within the ambit of the Act and an agreement or estoppel that operates outside the Act, and it is this distinction on which both Benedictus and the Upper Tribunal in this case relied. And Lord Justice Atkin gave 4 hypothetical examples of agreements which would fall within his first category, that is to say, agreements within the ambit of the Act. We can see that about halfway down page 235, for example, with the sentence beginning with, it is entirely different where the parties determined by agreement questions that arise within the Act, and then you get 4 examples, whether the person injured is a workman and so on. Now, I'm not going to pretend that those examples are straightforward. They've been the subject of debate in subsequent authority. I certainly don't say they are wrong. One would be very hesitant about submitting that any observation of Lord Atkin is wrong. But what I do say is that these hypothetical examples should be treated with some caution, and there are 2 or 3 reasons for that. The first is that this passage is obiter, because on the facts, the agreement between Mr. Dutton and his employer was found to be outside the ambit of the Act, not within it. So examples of agreements that would have been on the other side of the line are obiter. Second, and more substantively, the reason why Lord Justice Atkin gave those examples, which I accept on the face of it might be thought to undermine my submission, because in the first example it says you can by agreement determine whether the person injured is a workman, and I've been submitting a substantive precondition can't be waived. So it might be said that that undermines my submission. But the reason why Lord Justice Atkin gave those examples, as we read that passage, is not any general principle of law, but the unusual wording of subsection 3 of section 1 of the Workmen's Compensation Act 1906. Unusually, and I'll show the court that provision in a moment, it expressly permitted the employer and the workman to resolve by agreement any question relevant to the employer's liability, including the question whether the injured individual is a workman to whom the Act applies, which is Lord Justice Atkin's first example. And it was only if the employer and the workman were unable to resolve that by agreement would the county court judge get jurisdiction in the first place. Now, section 1.3 is not actually quoted fully in this judgment, but it is set out in another case we have in the bundle, which is the Clark case in the New South Wales Supreme Court, and that is tab 14, page 189. Again, just to put this into context, a fairly straightforward case. The injured employee in that case had applied to a statutory commission in Australia for compensation, again under a legislation. And the issue was whether the injured individual was a party to a contract of service or a contract for services. Because it's only if he had a contract of service, he'd be an employee and would be entitled to compensation. And in that context, the question arose whether the employer was stopped from disputing that it was a contract of service. And if we go please to page 194, there is a quotation, it's the penultimate paragraph on the page, from Lord Justice Atkin's judgment, the passage we've just been looking at, the 4 hypothetical examples. Then over the page, Section 1.3 of the 1906 Act is quoted in full, but it's only partially quoted in Dutton itself, which is why I wanted to go to this. What it says is, if any question arises in any proceedings as to the liability to pay compensation under this Act, including any question as to whether the person injured is a workman to whom the Act applies, or as to the amount or duration of compensation under this Act, the question, if not settled by agreement, shall be settled by arbitration. That clearly contemplates that there may be agreements which settle the question, though they do not arrive at the same result as an arbitrator would have arrived at, and at which therefore are not the interpretation which would be put upon the Act by a judge, and it contemplates that such agreements may be effective. And then Chief Justice Jordan in the New South Wales Supreme Court says this: no such provision is to be found in the New South Wales Act, and I think that the observation of Lord Justice Atkin, where his lordship speaks of the question whether a person injured is a workman to whom the Act applies, must be read with this reservation. So it is possible that what Lord Justice Atkin had in mind in that passage, which contains the 4 hypothetical examples, is not any general principle of law. Rather, he was making the narrower point that under that particular statute, it was open to the employer and the workman to resolve by agreement the question whether that person is in fact a workman.
Whereas they couldn't resolve by agreement whether poison gas was
Yes.
in the schedule or not.
Yes. And I accept, my lady, that that's not an easy distinction.
No, it isn't, is it?
It's not. And
You might say either was pretty substantive.
one might say that. But what I would say is that whether the injured person is a workman is expressly identified in Section 1.3 as something the employer and workman can determine by agreement. But whether the illness is within the Act is not expressly identified. So it's conceivable that Lord Justice Atkin treated these as limited exceptions to the jurisdiction principle. But as I say, I accept it's not easy. But the difficulty is, if one reads those 4 examples as general principles, then any substantive precondition could be turned into the subject of waiver, agreement, or estoppel, and that could not survive Essex County Council or Globe Elastic, which are subsequent House of Lords.
It questions the existence of a distinction.
Indeed. And it becomes very difficult to work. I apologise.
Which Lord Justice Atkin was drawing.
Indeed.
He was drawing the distinction.
Indeed.
It must exist in some form.
Indeed. And if you just go back for a moment to Dutton, there is a point which I think reinforces what your ladyship just put to me. At the bottom of 235, after giving the hypothetical examples and observing that on the facts, the agreement's outside the Act, Lord Justice Atkin says, if there be any agreement between the parties, it must be enforced by action at law and not by arbitration under the Workmen's Compensation Act. And then the last paragraph says this: it's unnecessary to consider whether in a case falling within the Act, there is place for the doctrine of estoppel in establishing liability, or whether the right view is not that the parties must rely on an agreement within the Act, and if so, whether such agreement to be valid must not be recorded in the register memorandum. Just to explain what that's about, in the passage we've been looking at, Lord Justice Atkin's not actually dealing with estoppel, he's dealing with an agreement. So you actually agree to pay the employee something to which he's not under the Act entitled. Lord Justice Atkin says even that can't be enforced under the Act if it falls outside the ambit of the Act, and that's not an easy distinction. But he then goes on to leave open the question whether you can have an estoppel. And the reason for that is that the 1906 Act contains quite prescriptive provisions about when an agreement between the employer and the employee may be enforced. There was a requirement to register it, I think, under Section 8, and then you'd have to sue upon the agreement and not the underlying facts. And it seems, so that just reinforces that the distinction is not founded upon a general principle of law, but on the particular features of the 1906 Act. And just before I leave the case, very quickly, but I'm mindful of the time, there was actually a few years before Dutton another Court of Appeal case called Standing in Eastwood. And in that case, there was a dispute about whether a particular individual was employed by the defendant. That was the subject of an alleged agreement, and the Court of Appeal held, Lord Justice Fletcher Moulton, that an agreement, even if it did exist, cannot enlarge the statutory jurisdiction of the tribunal. Standing and Eastwood is cited in Dutton by Lord Justice Warrington, apparently with approval, and it is unlikely, in my respectful submission, that Lord Justice Atkin was intending in any way to qualify it or depart from it. And one can see that at page 234 in the judgment of Lord Justice Warrington, who refers to Standing and Eastwood. So for all of those reasons, we would respectfully submit that the passage in Lord Justice Atkin's judgment at page 235, properly analysed, is not authority for the proposition that the parties may by agreement or estoppel waive a substantive precondition to the exercise of a statutory jurisdiction, and I've made the point that any such proposition could not survive Essex County Council or Global Elastic, and indeed their subsequent authority. So that's Dutton. Having looked at that, can I turn next to Benedictus, which is then founded upon Dutton? Benedictus is in the same volume, tab 13, page 173. Just to start with the facts, Jalaram Limited, the tenant, held a lease of business premises in southwest London. Jalaram made a request for a new tenancy under Section 26 of the Landlord and Tenant Act, 1954. Shortly thereafter, the landlord made an application for interim rent under Section 24 capital A. And then the tenant applied for a new tenancy under Section 24(1), stating in the application that they were in occupation of the premises. And the Landlord and Tenant Act, or this part of it, only applies to business premises of which the tenant is in occupation for business purposes. One can see the tenant's representation to that effect at page 175 in the judgment of Lord Justice Tucker. It's just at the end of the first paragraph where he's summarizing what the tenant had said in their form of application. They stated the following as particulars of their current tenancy. They state the address, etc. And then in answer to the question whether and if so, what part of the property comprised in the tenancy is occupied neither by the tenant nor by a person employed by the tenant, they answered no. So they were saying they were occupying the property. Now, what then happened is some years after this, the tenant wrote to the landlord saying they were actually not in occupation of the property. And because of that, their application for new tenancy was dismissed. They then resisted the landlord's application for interim rent, which had been pending all this time, on the ground that the court had no jurisdiction to determine it because they were not in occupation of the property. And the issue before the Court of Appeal was whether the tenant was precluded either by estoppel or by abuse of process. It's important to bear that distinction in mind from taking that point. At page 182, about halfway down the page, Lord Justice Stocker referred to the Dutton case. Then went over the page at page 183 towards the bottom, about 7 lines from the bottom. The learned Lord Justice said this, and just before that, we can see that he also refers to the hypothetical examples given towards the top of the page by Lord Justice Atkin. And then in the light of that, he says, having regard to the view which I formed upon this aspect of the case, I do not consider it necessary to refer to the other cases cited on behalf of the tenants, nor the cases cited to demonstrate the distinction between agreements or estoppel which purport to enlarge the jurisdiction of the court, and those which relate to an admitted state of facts essential to prove the cause of action arising within the ambit of the court's jurisdiction. In my view, it's clear law that the parties cannot by any route enlarge the jurisdiction of the tribunal before whom a matter falls to be decided. The question arising upon this appeal is whether or not the effect of the estoppel pleaded is to enlarge the jurisdiction of the court, or whether it concerns solely an estoppel which precluded the tenants from denying an essential fact necessary to establish their right to a new lease, namely that at the time of occupation, at the time of the application, the premises were occupied by the tenants for the purposes of a business carried on by them. Thus, in this case, the question and issue is whether the assertion that the tenants were not in occupation for the purposes of their business impugns the jurisdiction of the court, or whether it is one which arises within the ambit of the court's jurisdiction, as exemplified by the examples given by Lord Justice Atkin in the Dutton case. In my view, the tenant's contention does not give rise to any question of jurisdiction, but arises as an issue relevant to their claim for a new tenancy. Now, before I make submissions about that passage, I should just show the court what Lord Justice Bingham, as he then was, said. That's at page 185. About halfway down the page, Lord Justice Bingham said he was actually inclined initially to allow the tenant's appeal. He says, I was initially inclined to accept this argument as sound, being generally supported both by the passage in Spencer Bower and by Dutton. Then Lord Justice Bingham says that closer examination of Dutton reveals the answer, which lies in the hypothetical examples given by Lord Justice Atkin. And then over the page, Lord Justice Bingham said that the alleged estoppel operates within the ambit of the Act in Lord Justice Atkin's formulation, and therefore that the tenant was stopped. But then, over the page at 187, Lord Justice Bingham concludes at the bottom of the page that whether or not there was an estoppel, it was in any event an abusive process for the tenant to take the point that it was seeking to take. Now, ladies, my lord, we respectfully submit that there are three reasons why the Upper Tribunal was wrong to rely on Benedictus to reject our case that the jurisdiction principle is engaged. First of all, Benedictus does not attempt to formulate any new principle or to qualify the scope of the jurisdiction principle as set out in the authorities we've already looked at. It is rather a case about the application of that principle to the Landlord and Tenant Act 1954. And what the Court of Appeal did in that case was to treat the issue of whether the tenant is in occupation as a non-jurisdictional issue, such that it could be the subject of agreement or estoppel. That may or may not be right, but whether it's right or not, if we are right that as a matter of construction of this legislation, the status of an applicant under Section 88 is jurisdictional, then there is nothing in Benedictus which detracts from that. Second, if contrary to my first submission, Benedictus is to be regarded as authority for a more general principle of law, we would respectfully submit that it should again be treated with some caution. For one thing, my ladies, my lords, it's not clear if the significance of Section 1, subsection 3 of the Workmen's Compensation Act 1906 was drawn to the attention of the Court of Appeal in Benedictus in what appears to have been an extempore judgment, but the report rather suggests that it was not. If Section 1.3 had been drawn to the Court's attention, it is conceivable that Benedictus would have been decided differently on the estoppel point, if not the abuse point, because the 1954 Act does not contain any provision along the lines of Section 1.3 permitting the parties to decide for themselves whether the tenant is an occupation of the property or not. Third, if I can invite the court for a moment to go back to what the Upper Tribunal said about Benedictus, that's co-bundle tab 7, page 92. Para 31. So I apologize, it's actually para 34 at page 92, where the Upper Tribunal said it is in para 34, the error we would submit lies in the second sentence. It's not an enlargement of the jurisdiction of the FTT to award costs, which remains exactly as defined in the statute. But the fact that there's an estoppel preventing the other party from denying that they are a landlord is not an answer to the jurisdiction principle. If it were, the jurisdiction principle would be redundant, because it could always be said that the missing element which the parties are seeking to fill by agreement or estoppel is in fact not missing, because it's there by virtue of the estoppel or the agreement. But the whole point about the jurisdiction principle is that the missing element must actually be there. In other words, it must be there independently of the estoppel or the agreement. Because the internal logic of the Upper Tribunal's analysis at para 34, if one applies that to a case like Globe Elastic or Essex County Council, it could equally have been said in those cases that the missing statutory element is not missing because it's there by virtue of the estoppel. But that, in my respectful submission, is not an answer to the jurisdiction principle, but in fact reveals that the Upper Tribunal erred in law. Now, I did wonder in making these submissions about Benedictus whether it is ratio or obiter. It probably doesn't matter, because I don't need to submit that it is wrong. But to the extent it does, we would submit that the analysis of estoppel in Benedictus is actually obiter, because both, well, certainly Lord Justice Bingham and probably also Lord Justice Stocker ultimately decided the case on the ground of abuse of process. Because what happened was that, having rejected, I accept, the attempt to invoke the jurisdiction principle, Lord Justice Bingham and Lord Justice Stocker found that the judge below should nonetheless have allowed the parties to lead evidence as to whether the other elements of the estoppel were satisfied, things like reliance, which hadn't happened. They then concluded it's not necessary to send the case back, because anyway, on abuse of process, the landlord wins. But that, as we read the judgment, means that the analysis of estoppel was not in fact an element necessary to the ground on which the case was decided, namely abuse of process, and therefore it's obiter. Now, before I leave Benedictus, there is a hint in para 11 of my learned friend skeleton argument that they intend to run a fallback case, that even if I'm right about estoppel, it's an abuse for me to take the point, just as it was an abuse for the tenant to take the point. I don't know if that point is being taken. It's not in the respondent's notice. So it's not open procedurally, but substantively, we respectfully submit it's a bad point. And the reason why emerges from the judgment of Lord Justice Bingham, if you could just go back to that, please, at the bottom of page 187. The reason why the tenant's conduct was found to be abusive was that it was seeking to go back on a prior position it had adopted in relation to a question of fact within its own knowledge, namely whether it was an occupation of the property. Now, the tenant must always have known the answer to that question. You know whether you are an occupation of a property or not. It represented to the court, and I showed your ladyships and your lordship that, it represented to the court in 1983 that it was not an occupation, that it was an occupation, and subsequently sought to resile from that in resisting the application for interim rent. But by contrast, whether Assethold is a landlord or not is not a question within my client's knowledge, but rather a matter within Assethold's knowledge. So there is no possible abuse argument on these facts, even if it were open to my learned friends to take it, which we would respectfully submit it is not, absent an amendment to the respondent's notice. So that, subject to the court, is what I wanted to say about Benedictus. The Upper Tribunal also relied on one further authority, Plintel, but I was proposing to leave that to reply, if I may. But in a nutshell, it doesn't, with respect, really assist, because it doesn't contain any new statement of principle or indeed any detailed reasoning. And as an Upper Tribunal judgment, without intending any disrespect or discourtesy, it could not in any event modify the principles in the House of Lords and Court of Appeal authorities that I have referred to. So to conclude on issue 1, the jurisdiction principle is the first reason why we say that the upper tribunal erred in law in this case. But the jurisdiction principle is in fact only an instance of a more general principle that an estoppel cannot contradict or alter the effect of a statutory provision. And that takes me to issue 2, which is addressed in paragraph 48 of our skeleton and following. And issue 2 is, even leaving aside the jurisdiction principle, is the estoppel identified by the upper tribunal inconsistent with the 2002 Act for other reasons? And we respectfully submit that there are 2 reasons why it is. The first of those reasons is that the estoppel would produce, we would suggest, anomalous consequences that undermine the legislation. Now, the starting point for this argument is to identify what the estoppel actually is. And as to that, there are 2 different formulations of it in the upper tribunal's judgment, a wider formulation and a narrower formulation. The narrower formulation is that my client is estopped from denying that Assethold is a landlord for the purposes of Section 88 of the 2002 Act alone. That is to say, we are estopped for cost purposes alone, but apparently not for other purposes. The wider formulation is that my client is estopped from denying that Assethold is a landlord for the purposes of the 2002 Act generally, not just for costs. Just for the court's note, the narrower formulation appears at paragraphs 50 and 22 of the upper tribunal's judgment. That's co-bundle 50 and 22. So I'm sorry I took that in reverse order. It's only because 50 is clearer than 22. It's pages 96 and 90 of the co-bundle. That's the narrower formulation. Perhaps we can just look at that if it would assist. Paragraph 50. At page 96. So the final sentence, it says, is reflected in the legal position that the RTM is estopped from denying that the appellant is the landlord for the purposes of recovering costs. Paragraph 50 at page 96. So the estoppel, as they're formulated, is only engaged in respect of the costs issues. But elsewhere in the judgment, you don't get that limitation. It's rather formulated in a more general way that we are estopped from denying that Assethold is a landlord for the purposes of the 2002 Act. For instance, paragraphs 39 and 49 at pages 93 and 95. Now, it's not altogether clear which of these 2 formulations the upper tribunal intended to adopt. But insofar as it's the wider formulation, that is to say, estoppel for the purposes of the 2002 Act generally, it would, we submit, not only produce anomalous consequences, but is actually unworkable. I don't say that in respect of the narrower formulation, but I've got other reasons why we say the narrower formulation is not sustainable. But just taking the wider formulation, one example of why we say it's unworkable is in section 91 of the 2002 Act, which is page 29, volume 1, tab 1, page 29. So section 91, again, just to put it into context, section 91 and the provisions that come after it are all concerned with something that didn't happen in this case, which is what happens if the RTM company successfully acquires the right to manage. So you make the claim, the landlord opposes it, but you win, so you've got the right to manage. What happens thereafter? Now, section 91, subsection 4, defines an existing manager of the premises as any person who is a landlord under a lease relating to the whole or any part of the premises, a party to such a lease, otherwise known as landlord or tenant, or a manager. So that's actually the same form of words that one finds in section 88.1, section 79.6, and in other provisions, the 3 categories of person. Now, what happens once the right to manage is acquired is that these people who are defined as existing managers are under statutory obligation to give notices to third-party contractors with whom they have contracted, telling them that, look, now the right to manage has been acquired by the RTM company, so you're going to have to deal with them. That is at section 92 at page 31. So one can see that in section 92 subsection 1, the person who's a manager party must give a notice in relation to the contract to the person who's the contractor party and so on. And then at section 93, existing managers or landlords are also obliged to provide the RTM company with information that is reasonably required in connection with exercising the right to manage. That's section 93 subsection 1. And then perhaps even more significantly, at section 94 at page 34, landlords are obliged to pay to the RTM company an amount equal to the accrued but uncommitted service charges held by them on the acquisition date. And the rationale for that is, once the right to manage is acquired, what the landlord was previously doing now falls to be done by the RTM company. So if you've got accrued but uncommitted service charges, it's right that those should now be paid to the RTM company. But the point I make, my ladies, my lord, is this. If someone is not actually a landlord, then it is very unlikely that they were intended by Parliament to be under all of these obligations, which they would actually not be capable of performing. They wouldn't have any accrued or but uncommitted service charges, nor any contracts with third-party contractors, and so on. Yet, on the Upper Tribunal's wider formulation of the estoppel, that is to say, estopped for the purposes of the 2002 Act generally, the RTM company would apparently be estopped from denying, even for these purposes, that Assethold is not a landlord. And that must mean one of two things. Either it means that people who are not landlords at all come under these obligations, or it means that the landlord can deny that they are a landlord for these purposes, but the RTM company can't. But on either basis, we would suggest there are difficulties with the Upper Tribunal's analysis. If both parties are bound by the fiction that one of them is a landlord, then statutory obligations which are meant only to apply to people who are actually landlords and would end up applying to people who are not, who have no ability to comply with them, which is unlikely to be what Parliament intended. If, on the other hand, the landlord can deny that he's a landlord, so when he's asked to pay these accrued but uncommitted service charges, he can say, I don't have the money, I'm not a landlord. Landlord can say that, but the RTM company can't. Then it's unclear how there's even an estoppel to begin with on the wider formulation. Because if the representee, whose detrimental reliance it is the purpose of an estoppel to protect, is free to ignore the estoppel, then there isn't an estoppel in any real sense of the term. So the wider formulation, on analysis we would submit, collapses into the narrower formulation. The only workable estoppel you could have in this case is an estoppel for costs purposes alone. That is to say, the formulation one gets at paragraph 50.
I'm not sure I've quite followed this. Take the example of section 94, which is the duty to pay accrued uncommitted service charges. And the RTM company goes to Assethold Limited and says, pay me over everything you've got. And Assethold Limited says, I'm not a landlord. And RTM company says, oh, but there's an estoppel by convention and you ought to be treated as a landlord. At that point, Assethold simply says, well, I don't have any uncommitted service charges. I only have to pay over those which are held by me on the acquisition date. I don't hold any, so there's nothing to pay over. What is the problem?
No, I accept that, my lord. Your lordship is right. If they don't have the money, then that would be a reason they can give and they wouldn't be in breach of the obligation. I think my submission is directed at a prior point, which is, could the provision have been intended even to apply to someone who's not a landlord, irrespective of whether, on the facts of an individual case, they actually have the money? Because it's true that if they don't have the money, then they can say, well, I don't have the money, so I don't have to pay you. But there's a prior point, which is this provision even engaged in respect of somebody who's not one of the three things specified there? And my submission is that Parliament is likely to have intended that these provisions, not just 94, but the other ones we've looked at, were only intended to be applicable to people who actually have the status there specified. To put it another way, it's not clear how an estoppel could arise or how it would work in relation to these provisions. I mean, 94 is one example, but the other one, for instance, 91 or 92, which says the manager party must give notices to third-party contractors. I mean, I accept, picking up on your lordship's question, somebody who's not actually a landlord could say, well, I'm not a party to any third-party contracts, so I don't have any notice to give. And I accept that it wouldn't cause a practical problem in that sense. But analytically, if one asks, was this provision intended to apply to somebody who's not actually a landlord? My submission, the answer to that is no.
Okay. Thank you.
So that's the first reason, leaving aside the jurisdiction principle, why we say the estoppel undermines the 2002 Act, insofar as it's founded on the wider formulation. The second reason is what I will call, if I may, the action strength point after the House of Lords decision. And the point is this. The estoppel identified by the Upper Tribunal, whether the wider formulation or the narrow formulation, is inconsistent, we say, of the 2002 Act because it would, in effect, repeal the landlord requirement in Section 88. Now, this is addressed in paragraph 56 and following of my skeleton as issue 2B. And I've already identified the two formulations of the estoppel that one gets in the Upper Tribunal's judgment. But what is significant for present purposes is to ask, where does the estoppel come from? The answer to that is the same for both formulations. Both formulations of the estoppel are said to arise merely by virtue of the fact that the RTM company issued proceedings against Assethold and named it as a landlord in the form of application used to commence proceedings. Neither the Upper Tribunal nor my learned friends have identified any source for the alleged estoppel other than the fact of issuing proceedings and the form of application.
Can we have a look at the form of the
Yes,
application?
of course. Yes, of course. It is in the supplemental bundle. I'll just get to that. It's tab 15, my lord, page 161. So if one goes to page 163, there's a box number 3, it says address of landlord, if not given above.
Name and address, because the name doesn't seem otherwise to appear. Yeah, I mean, the large heading is address of landlord. But
Yes, it is name and address, indeed. And I obviously accept that what my client did in this application, form of application, was to name Assethold in this box and to provide its address. And that is said to be the source of the alleged estoppel, in addition to the very fact of issuing proceedings against Assethold. Now, the reason why I draw attention to this is if this is the source of the alleged estoppel, then it would arise in every single case in which the RTM company commences proceedings by wrongly naming somebody as a landlord. Which may well happen because, as I submitted earlier, whether the respondent is a landlord is not usually a question within the RTM's company's knowledge. It might know it, it might get it wrong. But if the estoppel would arise in every single case where you name a wrong landlord, then it would in effect repeal the landlord requirement in Section 88 for cost purposes, because non-landlords could recover costs in every single case in which they might seek to do so.
How does this point really differ from your first issue? I'm having some difficulty identifying it really as a separate point. Is it really another way of expressing that point?
They're certainly related, my lady, but I think the analytical distinction is this. It may not matter on the facts of our case, but one can envisage cases where the court isn't exercising any statutory jurisdiction. So let's say it's a commercial court claim or a Chancery Division claim where the High Court has general jurisdiction, but the claim is made under some statute because that's what furnishes the cause of action. And it is said that one or other element of that statute is satisfied by estoppel. Now, if, and I'm about to go to an authority on this, if that would mean that in every single case where this might happen, the estoppel would arise, then by admitting the estoppel, one is effectively repealing that statutory requirement, but one isn't enlarging any court or tribunal's
okay, so you're framing the first issue in terms of
jurisdiction, indeed.
Jurisdiction, whereas this is expressed not by reference to the tribunal.
Yes, yes. The distinction's elusive in our case because we have a jurisdiction issue. Yeah. That's why I give the example of the Chancery or Commercial Court claim. And actually that's what happened. But what I would say, my ladies, they are certainly related and they share a common rationale, which is that it would undermine or circumvent what Parliament has done to admit an estoppel. That would either confer rights and obligations which were not intended by Parliament to be conferred, which is issue 2, or enlarge the statutory jurisdiction of a court or tribunal, which is issue 1. But I certainly accept they derive from the same sorts of considerations. Now, the action strength case, which is why I've called this the action strength point, was a case that was pursued in the ordinary civil court. So it's not a jurisdiction case. And the issue was whether it was concerned with Section 4, the Statute of Fraud, 1677, which in its original form rendered unenforceable 5 classes of agreement unless the agreement was in writing. Originally, before subsequent amendments, one of those 5 classes was a contract for the sale of land. Another was, and still is, contracts of guarantee. So if you can't have an oral guarantee. Now, what happened in the action strength case, and I'll go to it in a moment, is that action strength was a subcontractor to a company called Englen, which was constructing a float glass factory for the owner, Saint Gobain. At one point, action strength, the subcontractor, becomes concerned about non-payment, its bills are not being paid, and it threatens to withdraw its labor. It says, I'm not going to work on the site anymore. That would have been disastrous for Saint Gobain because it wouldn't have got his factory. So what Saint Gobain was alleged to have done was persuaded action strength to come back by guaranteeing the debts owed to it by England. But the guarantee was oral, not written. So Saint Gobain doesn't send any email or any letter, perhaps in those days, saying we will guarantee these debts. The relevant individual says on a telephone call, if things go wrong and you don't get paid, we pay. Now things did go wrong, they didn't get paid, and they brought a claim. And Saint Gobain applied to strike out the claim on the ground that even if all the facts are true, the claim is barred by Section 4 of the Statute of Fraud, 1677. And then the issue arose whether there's an estoppel preventing the creditor from taking the point. And the House of Lords said that there cannot be an estoppel, and we should just look at the reasons why. It's Authorities Bundle 1, tab 11. It starts at page 145. The relevant passage is in the speech of Lord Hoffman at para 26, page 154. So Lord Hoffman says at para 26, the difficulty which faces this submission, the estoppel submission, is that while the nature of a sale of land is such that the contract and part performance can coexist in their respective domains, no such coexistence is possible between the statute and the estoppel for which counsel contends. It is in the nature of a contract of guarantee that the party seeking to enforce it will always have performed first. Unless he has advanced credit or forborne from withdrawing credit, there will be no guaranteed debt for which he can sue. It will always be the case that the creditor will have acted to his prejudice on the faith of the guarantor's promise. To admit an estoppel on these grounds would be to repeal the statute. Now, just to unpack that, if I may, Lord Hoffman refers in the first sentence of para 26 to the doctrine of part performance, which he then distinguishes from contracts of guarantee. Now, the doctrine of part performance was a doctrine the courts had evolved when the statute of frauds still applied to contracts for the sale of land. And without going into too much detail, but in a nutshell, the doctrine was that if you have a contract for the sale of land which is not in writing, but the parties in fact perform it, what they have in fact done would be treated as evidence of what the agreement was, and then it might become enforceable. But Lord Hoffman was making the point that the doctrine of part performance would not have the effect of repealing the statute of frauds, because there would be any number of cases in which it wouldn't be engaged on the facts. For example, if a contract for the sale of land is wholly executory, so nobody's done anything, the doctrine will not be engaged. But because it's not in writing, the contract will be unenforceable under Section 4. But Lord Hoffman then distinguishes that from contracts of guarantee. And the point he's making is, if you can have an estoppel in relation to contracts of guarantee, you would by definition have it in every case. Because if I guarantee somebody's debts, I only do it because I want them to get the money. And it's in reliance on my guarantee that the lender will have advanced the money. So there will be reliance. So if that bare fact was sufficient to generate an estoppel, then Section 4 of the Statute of Frauds would by estoppel have removed the contracts of guarantee requirement. There would be no case involving a contract of guarantee in which Section 4 would ever be engaged. And that's what Lord Hoffman meant at the top of page 155. To admit an estoppel on these grounds would be to repeal the statute. Now, one point that did occur to me is, how far does this go? I mean, is it necessary to demonstrate that in every conceivable case on any kind of fact pattern, admitting the estoppel would defeat the statute, or is it sufficient to demonstrate that in the vast majority of cases, the estoppel identified by the court or tribunal would have the effect of undoing what Parliament has enacted? This case doesn't answer that question. We would submit it's probably the latter, because the rationale for this is if Parliament has said you cannot enforce contracts of guarantee unless they're in writing, it would be wrong to circumvent that through an estoppel. Now, that rationale is probably engaged, even if one can identify a rump of cases in which the estoppel would not kick in, maybe because there's no reliance. But in this case, my ladies, my lord, if the bare fact of issuing proceedings against someone who's not a landlord generates the estoppel, and that's what the Upper Tribunal found, there will be no case, or virtually no case, in which a non-landlord would be unable to recover their costs. They could always rely on the estoppel. So it would, in my respectful submission, repeal the landlord requirements in Section 88, to use Lord Hoffman's terminology. Now, the Upper Tribunal's answer to the action strength point is to be found in paragraph 36 of its judgment. That is co-bundle tab 7, page 93. So at para 36, the Upper Tribunal says that principle, the action strength principle, is not relevant here because we are not here dealing with a transaction which would have been valid at common law but fails the statutory criteria for validity. The appeal concerns a purely statutory regime and the potential for one of the parties to be stopped from denying that a fact that is necessary for the operation of the statutory regime. There is no sense in which allowing that estoppel to go to the heart, would go to the heart of the statutory regime in such a way as to repeal it. So as I read that passage, the Upper Tribunal is making two different points. The first point of distinction identified with action strength is that action strength was concerned with a transaction that would have been valid at common law but failed the statutory criteria for validity, whereas this case is concerned with a purely statutory regime. Now, that is true, but with great respect irrelevant, because it is not an answer to the point Lord Hoffman was making, namely that an estoppel that would in effect repeal a statutory requirement is excluded by the statute. Indeed, it would, we would suggest, be illogical to confine the action strength principle to statutory requirements that happen to relate to common law claims, as distinct from statutory requirements concerning statutory claims. Because what matters for the purposes of the action strength principle is the fact of a statutory requirement that is in effect repealed, not the content of that requirement. So the first point of distinction identified by the Upper Tribunal is, we respectfully submit, flawed. The second point at para 36, which is in the penultimate sentence, is that there is no sense in which allowing that estoppel would go to the heart of the statutory scheme in such a way as to repeal it. And that respect, it's not entirely easy to follow what the Upper Tribunal meant by heart of the statutory scheme. What the Upper Tribunal seems to have meant is that the estoppel only concerns costs and not the rest of the statutory scheme. On the narrower formulation, that's true. On the wider formulation, it's not. But on either basis, it is, again, with respect, irrelevant, because the question for the purposes of the action strength principle must be not whether the statute as a whole would in effect be repealed, but whether the estoppel would in effect repeal the particular provision in relation to which it's set up. Indeed, in action strength itself, Lord Hoffman said it is section 4 of the Statute of Frauds insofar as it applies to contracts of guarantee, which would in effect be repealed by admitting an estoppel. By parity of reasoning, the landlord requirement in section 88(1) would in effect be repealed by admitting an estoppel, and it is nothing to the point whether some other provision would in effect be repealed or not, any more than it was in action strength. So the action strength point is a further reason why we would say that the Upper Tribunal erred in law. That, subject to the court, is all I wanted to say about issue 2. Safe to make one final point, just standing back as it were, which reveals what we would respectfully submit is perhaps an overarching flaw in the Upper Tribunal's analysis. Now, my ladies, my lord, as I've submitted, the assumption for the purposes of my appeal, that is to say my grounds of appeal, leaving aside the respondent's notice, the assumption is that Assethold is not a landlord. Now, it so happened that in this case, my client's claim for a right to manage was dismissed by consent because it was withdrawn. So it wasn't actually fought out before the first year tribunal. But that's happenstance. If Assethold is not a landlord, which is the assumption for present purposes, then my client's application under section 84 for a determination that it had acquired the right to manage would, had it been fought out, have been dismissed on the ground that Assethold is not a landlord and that the claim notice served on it is therefore invalid. Now, as I say, that didn't happen because the claim was withdrawn, but that's what would have happened had it been fought out. But if that had happened, then the FTT would have made a positive finding that Assethold is not a landlord.
Sorry, this may not matter. Would it necessarily have been dismissed? Does it matter if a claim notice is served on someone it doesn't need to be served on?
No.
I understand
yes.
that the claim notice was actually served on Milcastle as well.
Yes.
That's what we're told.
Yes, that your ladyship is right. It may be that if we had also, what I was positing was we serve it only on Assethold, but your ladyship's right. If we also serve it on somebody who's in fact a landlord, such that we have served a valid claim notice under 7.
I can see your point that in determining the outcome of the proceedings, the tribunal could possibly have said, Assethold, you are not a landlord, so you don't have any standing to serve a counter notice or object.
Yes, quite.
And then whether the right to manage proceeds would depend on other
Yes.
matters.
Yeah, that, with respect, is a better way of putting it, my lady, because I'm not sure it matters for the purpose of the point I'm about to make, whether the claim notice would have been valid or not. The point I was going to make is only that if the claim had been fought out, then the FTT would have had to make a finding about whether Assethold is a landlord or not, either to determine whether it has standing or for some other purpose. The point is that would have had to be decided even before you get to costs as part of the substantive proceedings. And one can actually see, if we go to the FTT decision on costs, that's 4 bundle tab 13, para 20, page 136, para 20. So the FTT has made a finding in the costs litigation, I accept, that Assethold was not a landlord under a lease of the whole or any part of the property when the claim notice was served, as it had no legal interest. This means the claim notice was not given to it under section 79(6). It had no standing to serve a counter notice and has no standing to claim costs. Now let's imagine for a moment that that finding had been made, not in the costs litigation, but in the substantive proceedings, because they had been fought out. It would, we would respectfully submit, be surprising if after seeking and obtaining such a finding from the FTT, Assethold could then turn around and contend that it is, after all, a landlord, whether in reality or through an estoppel, such that it can recover its costs. Indeed, it's not easy to see how Assethold would even be able to advance that argument if the FTT has already determined on Assethold's invitation that it is not. I mean, the only way it could be done, as it seems to me, is by saying landlord means something different in section 88 from every other provision of the 2002 Act, but that point's never been taken, and for the reasons I gave earlier, we would say that's a bad point. You get the same wording in all of these provisions. So in the hypothetical I'm positing, where this issue gets fought out in the substantive proceedings, the estoppel argument would not be available to Assethold at the cost stage, because it would already have sought and obtained the finding that it's not a landlord.
Sorry, why would Assethold wouldn't have? Maybe it doesn't matter again, but it wouldn't be Assethold making that, seeking and making that finding.
Unless there were an issue about its standing.
It would have been the RTM company that would have been.
Yes. Yes, but yes, it may be that Assethold wouldn't have sought it, but there would have been a finding either on Assethold's, either involving Assethold or not, depending on whether there's a dispute about its standing. But one way or another, the likelihood is if this issue gets fought out in the substantive proceedings on somebody's invitation, the FTT is going to find that Assethold is not a landlord. The only point I'm making is that if the FTT has already made that finding at the substantive stage, it would be surprising if that could then be undone at the cost stage through an estoppel. Because whether there's an estoppel or not shouldn't turn on the happenstance of whether the issue gets fought out at the cost stage or at the substantive stage. Either there's an estoppel for cost purposes or there isn't. And what we would respectfully submit the use of the estoppel in this case amounts to is an attempt to rewrite Section 88 by expanding it to include persons who are asserted to be but are not landlords. But that is not what Section 88 says, and to seek to achieve that result through an estoppel is, we would respectfully submit, contrary to principle.
What was the ground on which your clients withdrew their application?
I don't think the notice of withdrawal identifies one, my lord. What I can say is that after the claim notice was served, a counter notice was served identifying, I think, 6 grounds of opposition. Then Assethold served a skeleton argument, abandoning some but developing others. And then one day before the hearing, my client served, or 1 or 2 days before the hearing, my client served notice withdrawing the claim. My recollection is it doesn't specify the ground of withdrawal, but I'll check that and I'll come back to your lordship if I may, if I'm wrong about that. But if your lordship's question is, was it anything to do with Assethold's status as a landlord or otherwise, it wasn't. There was a dispute about whether these premises are covered by the 2002 Act, whether we had served a notice of invitation to participate on qualifying tenants and those sorts of things. And as I say, none of that was in the event determined.
Was it any part of Assethold's objections to the proceedings that it wasn't actually the landlord?
No, on the contrary, and I was about to develop this on issue 3, its position throughout has been that it is.
I see. Thank you.
And indeed, one of the points it took, and I'll come to this shortly, is that we hadn't served some other landlords as well. But I was going to turn to issue 3, which is, assuming I'm wrong on issues 1 and 2, then the court will have concluded that an estoppel, if it otherwise arises, is not excluded by the 2002 Act. But then the question at that stage of the analysis is, does it otherwise arise? In other words, are the ordinary requirements of estoppel, leaving aside the statute, satisfied? Now, in its pleadings in the courts below, Assethold did not identify any particular form of estoppel. But at paragraph 49 of its judgment, the Upper Tribunal identified 2, estoppel by representation or estoppel by convention. And I'll take those in turn, although I think I will probably be able to cover the ground just by referring to estoppel by representation. There are 3 reasons why we respectfully submit that there can be no estoppel by representation in this case.
Sorry, just before we go on, you may be about to cover this, but one of the oddities is, I think you said this earlier, the only representation said to arise is filling in the form when you apply to the tribunal. And you only apply to the tribunal once a counter notice has been served, yet the cost jurisdiction covers both the process that leads to the counter notice and the proceedings.
Yes.
So there appears to be, in any event, a problem with the first stage of the costs.
Well, I respectfully agree, my lady. It's a point I was going to make, because one of the problems with the Upper Tribunal's analysis, and if I'm wrong about everything else, the estoppel can only kick in from the date of the form of application which names Assethold as a landlord, which presumably would mean that the RTM company is not liable for costs that were incurred before then, because there's no estoppel at that stage. There's no representation that's made until September 2021, which is when the application is made to the first-year tribunal, naming Assethold as a landlord.
Well, I struggled a bit with what the UT say about this, because they seem to focus on the cost of proceedings.
Yes. Although my understanding, and no doubt my learned friend, because he was in the courts below and I wasn't, will correct me if I'm wrong, but the claim actually made to the Upper Tribunal was not confined to the costs of proceedings. It was all the costs to which they are entitled under Section 88, if it applies, either actually or by virtue of an estoppel, which would include costs incurred between June and September 2021, so after the claim notice is served and before the proceedings commence. Yet, if there is an estoppel by reason of what was said in September, one would presumably have to exclude the costs incurred between June and September. But the legislation doesn't draw any such distinction. So in a way, it's a point that goes to issues 1 and 2, which is if the estoppel arises out of the fact of issuing proceedings, then it would force the court or the tribunal to draw a distinction between pre-proceedings costs and costs incurred in the proceedings themselves, which is not a distinction Section 88 draws. So it's a further indication, in my respectful submission, that the estoppel is actually excluded by the 2002 Act. But on the premise I'm wrong about that, we say there are 3 reasons why there is no estoppel by representation in this case. First, no relevant representation was made by my client. Second, if a representation was made, it was not intended to be acted upon, nor could it reasonably have been acted upon. And third, in any event, the representation was not in fact acted upon. Now, turning to the first point, what was the representation? I've already identified the 2 formulations we get, the wider and the narrower formulation. The narrower formulation, which is, as I've submitted, the only workable formulation, is that Assethold is a landlord for cost purposes alone, that is to say, for the purpose of Section 88 alone. Now, we say that my client never made any representation in those terms, let alone clearly or unequivocally, which is the test. Because and we've looked at this before, the source of the representation is the form in the supplemental bundle which may be worth turning up again. Supplemental bundle, page 163, tab 15, page 163. Now, that doesn't, it's an obvious point, but perhaps worth making nonetheless. This box 3 doesn't say anything about costs or section 88. All it does is name Assethold as a landlord and give its address. Now, putting the respondent's case at its highest, this might amount to a representation that Assethold is a landlord for the purposes of the 2002 Act generally. But it could not, in my submission, amount to a representation that Assethold is a landlord for the purposes of section 88. But that's what the respondent would need to sustain the narrower formulation of the estoppel. So what then follows from that is, it's only possible to generate an estoppel in terms of the narrower formulation by reading down the representation actually made from a representation that Assethold is a landlord into a representation that Assethold is a landlord for one purpose alone, namely costs. Now, we say there's no linguistic basis for doing that, but it's also contrary to the guidance given by this court in the Northern Rock litigation. Although in fairness, I should acknowledge that the Northern Rock case was not cited to the Upper Tribunal. Now, it's at volume 2, tab 24, page 348. And the relevant passage is in the judgment of Lady Justice Gloucester, who gave the judgment of the court, paragraph 55 at page 377. An estoppel as to the applicability of the Consumer Credit Act in this case. Paragraph 55 at page 377. A further reason is that, again, as we have already stated, the language of the express references to the 1974 Act in the relevant statements is not consistent with a joint assumption on the part of the lender and borrower, or a representation by the lender, but, and this is the important bit, that some but not all of the provisions of the 1974 Act apply. As the relevant textbooks make clear, on any basis a borrower would not be entitled to invoke the doctrine of estoppel to engage the court's jurisdiction to refuse to make enforcement orders under section 127 of the 1974 Act in circumstances where a non-regulated agreement had not been executed in compliance with the proper execution provisions applicable to regulated agreement. And then skipping over the next few lines and picking it up just below letter C on page 378, if I may. And just below letter C, Lady Justice Gloucester says, so if an estoppel were to arise in the present case, limited to those rights under the 1974 Act, which could have been included and enforced as contractual rights in an unregulated agreement, the estoppel would not reflect in the sense that it would be much narrower in scope, the breadth of the representation, which was not limited in any such way. There is no justification, in our view, for reading down the representation to limit it to those rights which could have been included and enforced as contractual rights in an unregulated agreement. Again, just to unpack that, what was happening in this case, I mean, the detail probably doesn't matter too much, is that between 1998 and 2008, the Consumer Credit Act 1974 was only applicable to loan agreements which did not exceed £25,000 in value, and then that was amended to remove the limit. Now, Northern Rock at the time used standard loan documentation for all of its loans, and the result was that they had a standard form of statement stating the Consumer Credit Act applies to this agreement, which they put in all of their agreements, including those which exceeded £25,000. The issue was, are they stopped by reason of that from contending that the Act does not apply to borrowers? But it was common ground that even if there's an estoppel, there are some provisions of the Act to which it could not reach. For instance, provisions conferring jurisdiction on the court. So the estoppel had to be read down. The statement the Consumer Credit Act is applicable had to be read down into a narrower estoppel, namely that the Consumer Credit Act is applicable in the following respects. And the point Lady Justice Gloucester was making is that there's no justification for doing that, because there was no representation in the narrower form, which was the only sustainable form of the estoppel. And we say that the same applies here. If the only sustainable form of the estoppel here is the narrower formulation, that is to say an estoppel for cost purposes alone, then the answer to it is there was no such representation. And reading down what was actually said would be contrary to principle for the same reasons it was contrary to principle in the Northern Rock case. So for those reasons, we say the first requirement, namely the existence of a representation, is not satisfied. If I'm wrong about that, the next question is whether the representation, if made, was intended to be acted upon, and whether it would have been reasonable to act upon it, because both of those are requirements that must be satisfied. The test of intention is, of course, objective in the usual way. So the question is, would a reasonable person in Assethold's position have considered that the representation made was intended to be relied upon? In other words, the representation in box 3 of the form that we looked at, which says Assethold Limited, would a reasonable person who served with that form understand that to be a representation that they are a landlord for cost purposes? Now, my ladies, my lord, what is distinctive about the representation in box 3 is that it was made in a form of application used by the RTM company to commence proceedings. And it is, we would suggest, inherently unlikely that any statement made in that form was intended to be relied upon by the respondent, because it was not made for the purpose of inducing the respondent to do anything. Now, I don't go so far as to say that it is impossible for a statement made in originating proceedings, a claim form, for instance, to be the source of an estoppel, but I do say it's quite unlikely. Because if you say something in a claim form, you say it because you want to start a claim, not because you want the defendant to do anything. It might be different if you write a letter saying what you understand the claim form to mean, or what you understand the defense to mean. But the bare fact of what you say in a claim form or in the particulars of claim is unlikely, in most circumstances, to be something that was intended by the other side to be relied upon. Mindful as I'm of the time, I'll take this very quickly. An analogy may be drawn with the Dutton case we looked at earlier, the gas poisoning case. Because as the court will recall, what happened there was that the employer had paid Mr. Dutton weekly sums, stated to be paid under the Workmen's Compensation Act 1906. And one of the issues was whether that constituted a representation that Mr. Dutton would be treated as a workman even if he actually wasn't. Lord Justice Warrington at tab 18, volume 1, tab 18, page 233. In the final paragraph on page 233, about 8 lines in, Lord Justice Warrington says, by submitting these forms, the respondents do no more than wrongly describe the money that they were paying, and they do not state or lead the man to the belief that they intend to treat him as entitled to compensation if he is in fact not within the Act. And in my respectful submission, the same analysis applies here. Box 3 in this form named Assethold as a landlord because that's what my client believed at the time. But it could not, in the words of Lord Justice Warrington, have led Assethold to believe that it would be treated as a landlord even if it wasn't. Especially for cost purposes. Indeed, to take a slightly imprecise analogy, if I commence a Part 7 claim, the Chancery Division, I may expect to have to pay the defendant's costs if I lose a trial, but I'm not representing that I will, or at least not representing that I will pay costs other than that to which they are in fact entitled. And there is a further reason which we submit underscores that this representation was not intended to be relied upon and could not reasonably have been relied upon, which is that the representation is one of opinion or belief, not fact. It might even be a representation of law. I mean, it depends on how one defines it, but if it's a representation that Assethold is a landlord for the purposes of Section 88, that is either a representation of opinion or law, or both. It engages questions of fact as well as law. Now, we accept there's no longer any absolute rule that a representation of law or opinion cannot give rise to an estoppel. It can do. But where it's the representation of opinion or law, it's unlikely to be reasonable for the representee to rely on it, at least if the representee is in as good a position as the representor to form its own opinion as to that matter. May I just give the court a reference without going to it? I hope your ladyships and your lordship will forgive me. It's Mr. Justice Nugee, as he then was, in Briggs and Gleeds, paragraph 31, that's Supplemental Authorities Bundle, tab 4, page 103. And Mr. Justice Nugee made the point that while you could have an estoppel arising out of a statement of opinion, that will likely be confined to cases where the person making the statement is in a better position than the person to whom it is made to form a view about it. But in this case, when...
Which paragraph is that?
Paragraph 31. I will go to it, my lord, if it would assist. I'm sorry.
That's all right.
It's paragraph 31, page 103 of the supplemental bundle.
Thank you.
Yes, tab.
I think we're familiar.
Tab 4, page 103. So that's what the whole of paragraph 31 really. A statement on a legal matter will often involve no more than a statement of opinion. And then just above letter H, moreover, where a statement as to the laws made by someone without legal expertise, it may be an objection to any estoppel that it was not reasonable for the person to whom the statement was made to act on it or to infer that the representor intended him to do so. And then where there is a representation as to a mere matter of law, it is in 19 cases out of 20 made by a person who does not know the law better than the person to whom it is made and at whose risk it is taken and acted upon. So we respectfully rely on that. And if that's right, then that's significant for this reason. When proceedings were issued in September 2021, in naming Assethold as a landlord, Assethold was represented by solicitors experienced in this area of the law. So it was not only in as good as, but in a better position than my client to form a view about whether it was a landlord or not, and could not reasonably have acted upon any representation made by the RTM company as to that matter.
Isn't there a further point on the facts which, if I've understood it correctly, the proceedings were issued in response to Assethold?
Yes, indeed.
And on what possible basis was Assethold serving the case?
Well, I'm grateful, my lady. That's exactly the point I was going to turn to. It demonstrates not only, and I respectfully agree, it not only demonstrates it wouldn't have been reasonable to rely, it demonstrates that there was in fact no reliance because they'd formed their own view as to whether they're a landlord or not. That takes me to my final topic, which is actual reliance. Assuming I'm wrong with everything else, that they actually rely on representation. Now, the Upper Tribunal addressed this in the final sentence of paragraph 49, core bundle, tab 7, page 95.
Sorry, what paragraph?
Core bundle, tab 1, page 75, paragraph 49. Sorry, have I given your ladyship a bad reference?
Yes, you have.
I'm so sorry.
Don't worry.
It's page
Paragraph
90.
49 will do.
Yes, page 95, paragraph 49. So it's really the final sentence where the upper tribunal says, as to detrimental reliance, the act of engaging with the proceedings and the incurring of costs are clearly detriments. Now, the error in my respectful submission in that finding is that the upper tribunal failed to ask itself whether those detriments were caused by the representation. In other words, whether there's a causal connection between anything said by the RTM company and Assethold's decision to engage with the proceedings and incur costs. Now, there could only have been a causal connection if what the RTM company had some impact on Assethold's mind. It must, as the authorities put it, have been either the source of the relevant belief or at least strengthened a belief which Assethold already held. But if it made no difference at all to what Assethold believed, so it wasn't the source of the belief and it didn't strengthen the belief, then it cannot have had any causal impact on Assethold's conduct. Can I just give the court a reference to that? It's actually a point made by Judge Cooke, writing extrajudicially. It's volume 2, tab 41, page 573. And the learned author says, the representation must not merely arrive at, but do something to the mind of the person addressed. So at a minimum, Assethold must establish in this case that the representation made in box 3 of that form strengthened its own belief that it was the landlord for the purposes of the 2002 Act. Now, not only is there no evidence of that before the upper tribunal, because Assethold did not lead any such evidence, which itself is fatal, we would submit, there's actually evidence the other way, which picks up on the point your ladyship was putting to me, namely that when it served the counter notice on 14 July 2021, I think, Assethold had evidently formed the view that it was a landlord.
Well, it's not capable of serving.
Well,
quite. Because as I recall, I don't think we've taken to it, but the list of people who can serve the landlord is that same list.
Exactly.
Counter notice is that same sort of list.
It's exactly, my lady. And in fact, your ladyship will recall paragraph 20 of the FTT makes that point. It says that unless you're the landlord, you have no entitlement to serve a counter notice. Now, it's not just the counter notice though. In fact, in December 2020, so months before even the claim notice was served, Assethold was representing that it is the freeholder. That document was not in evidence below. My learned friends have helpfully indicated that they don't object to my referring to it with the court's permission. That is supplemental bundle, tab 27, page 232. So this is a letter sent to the occupants of one of the flats in this property, 159E, Prince of Wales Road. If we go to page 234, please, at the bottom of the page. It says that the freeholder is Assethold Limited, that is to say the respondent in this case. So that was Assethold's belief before any arguable representation was made by my client, indeed before even the claim notice was served. But the claim notice did not actually represent that Assethold is a landlord. It used the conditional language, if you are a landlord, you're entitled to serve a counter notice. So it just reinforces the fact that if in December 2020 Assethold believed that it was the landlord, before anything was said by the RTM company, then serves a counter notice, all before the alleged representation in this case, then the representation could not have had any causal impact on its mind. Just to give the court a reference, the counter notice is at tab 29 of the supplemental bundle, and it's perhaps worth turning up actually. Supplemental bundle tab 29. So this is 14 July 2021. One sees paragraph 4 that one of the objections raised by Assethold was that the claim notice was not given to each person to whom it is required to be given under section 79.6. So they seem to be saying there are other landlords you haven't served, and so the claim notice is defective. But they could only say that if they had formed a view about who the landlords are.
I suddenly got the impression that this document was just listing every possible.
It's just a boilerplate, isn't it? It's the generic one that's served in every time they get a net claim form.
I suspect that's probably right.
There's Upper Tribunal authority bemoaning the fact that across the landlord spectrum, every point is taken on every occasion with no elucidation at all, and it isn't until pleading to find out what's going on.
As I said, it's a boilerplate.
Yes, I was trying to think the last time I was in front of you on one of these, I suspect I took many of the same points
Yes.
in exactly the same language. Yes. There's a phony war happened between claim notices and the counter notices. Everybody does the bare minimum to ensure validity because everyone is aware there's so much procedural case law it's trying to avoid falling into. That's the reality of it.
This counter notice doesn't itself say Assethold Limited is the freeholder, but your point is that under the Act you can only serve a counter notice if you're the landlord. Is that right?
That's right.
Or one of those other people.
Yes. And that's the point made in para 20 of the judgment of the FTT. And the final point on reliance is that there was in any event, I mean, even if I'm wrong about these points which go to the inherent likelihood of reliance, but even if I'm wrong about all that, as the party invoking the estoppel, the burden of proof was on Assethold. It did not lead any evidence before the first-tier tribunal that what was said in box 3 had any impact on the forensic decisions it made subsequently. And indeed, it is unlikely that it would have done, because if one imagines a slightly different world in which we had said in the form, Assethold may be a landlord, but we're not sure whether they are, it is most unlikely that Assethold would have chosen not to fight the proceedings. I mean, they would probably have come along and said all the other things they said in their counter notice, namely, you're not entitled to the right to manage for all these other reasons. So the alleged detriments would have been incurred anyway, irrespective of any representation. So for all of those reasons, we submit that the Upper Tribunal erred in law in finding that the ordinary ingredients of estoppel by representation are satisfied. I wasn't actually going to say anything about estoppel by convention because it's just the same points. You have the same reliance requirement, the same requirement for a common assumption. Now, that's everything I want to say on the appeal. But before I sit down, there is one point in fairness about the respondent's notice, which I ought to flag, because it occurred to me in preparing for this hearing that I have not made that point as clearly as I could and should have done in my reply skeleton. So it's right, my learned friend has an opportunity to address it if he wishes to. And the point is this. The main issue on the respondent's notice, which I'll address tomorrow, is whether someone with an equitable interest in the property constitutes a landlord under Section 88. And my learned friends make the point in their skeleton that under Section 24 of the Land Registration Act, equitable owners can do virtually everything that legal owners can do, and therefore they say they should be treated as a landlord. Now, we say, we don't accept that. We say that even if the respondent were to establish on the facts that it had an equitable interest in the property, which it hasn't done, that would not make it a party to any of the leases. Because there is authority that somebody with an equitable interest in a lease does not merely by virtue of the equitable interest become a party to it, which is why, for instance, someone with an equitable interest in a lease cannot serve certain notices. For instance, notice exercising a break clause in the case of a tenant, a notice to quit in the case of a landlord. And we do say that unless Assethold establishes that it actually became a party to the relevant leases, it is not within the statute. And as I say, I'll develop that tomorrow. There are two authorities in the bundle on it, but I thought I ought to flag that now. But subject to anything I can assist your ladyships or your lordship with, those are my submissions in opening.
No, thank you very much
Great
indeed.
for mine.
In that case, you can all have 5 minutes extra for lunch. Thank you very much. 2 o'clock, please.